Thank you, everyone. Please be seated. We are here this morning for two separate cases, and we're going to start with Selden versus Des Moines Area Community College. And it looks like the parties are ready, and Mr. Armentrout, you may begin.
May it please the court, counsel. Des Moines Area Community College proved that Brian Jaden's 29 years of computer programming experience, including 16 more years than the plaintiff Sandra Selden, in the very position, were factors other than sex as a matter of law, justifying that his salary should be greater than hers. Now, at trial, facing this massive amount of comparative evidence of the 29 years of experience, the plaintiff came up with a novel theory of comparing hiring percentages 16 years apart for Jaden and Selden. And we believe that it was improper for this theory and evidence to come in to permit this case to even get to the jury after the evidence was presented by DMAC of the factor other than sex. And first of all, we believe this is the case because 216.6A is the only claim that was brought by the plaintiff. Point 6, the intent discrimination portion was not used, and so we're not looking at intent here. Therefore, we can hopefully look at a lot of the federal cases that we have supplied to this court. There's simply not a lot of Iowa appellate decisions on the 2009 Iowa Equal Pay Act. I think we might be discussing the Dindinger case a little bit, but with regard to what is the quantum of proof for a defendant for a factor other than sex defense, what is the burden for the defense, those are all things that I think needed to be decided by this court.
Mr. Armentrout, one thing, sort of looking at the transcript of the trial, the person who actually hired Mr. Jaden, is how you pronounce his name? Okay, back in 1997, 1998. That person didn't testify, am I correct?
Honor, Art Ferris.
In the record why that person didn't testify?
I don't think that's indicated in the record, Your Honor. I think that does underscore one of the problems we have if the court's going to permit a comparator that's 16 years apart and go back. We believe that that stretches the presumption of strict liability beyond the breaking point, and it's an extraordinary burden for Iowa employers to go back that far, and your question illustrates that. By the time this case gets to trial, the supervisor, Mr. Ferris, no longer worked for DMAC. You know, that the longer you stretch that period of time, the harder it's going to be for employers to have to go back and justify the reasons, and we don't believe it should be that hard in a non-intent-based strict liability case like this one. And that's why we've cited cases like the Mayorga case, which is a very recent 8th Circuit case under the Federal Equal Pay Act. And the court took a look at what quantum of proof and what's the burden for employers on factors other than sex. And the court made clear that it's not like the McDonnell-Douglas burden shifting, where once the prima facie case is met, the burden shifts to the employer to prove factor other than sex. It doesn't shift back once the employer presents objective evidence of reasons, which a lot of the time is experience and longevity. And in that case, there was evidence that the comparator had 10 years more of experience. The court said that ends the analysis. There's no second guessing at this point or looking at the motivations of the hiring people. And we've also put in our brief cases like Chattel, which the court says that the court must only look at the objective evidence. In that case, the comparator had 5 years more of experience. And the court said that ends the analysis. You do not further weigh the evidence. In fact, in Mayorga, the court said,
does that analysis depend on whether or not the employer's justification is objective? So what if the employer just said, well, we think this person is going to be a better performer?
I think you're right, Ron. I think that is something that could be considered. The more objective, the more likely it is that the court can conclude that factors other than sex have been established. Things like experience. Here we have, for example, Mr. Jaden working 16 years in the position. That's an objective fact. There's really no way around it. But if it had been based on more subjective criterion like you're suggesting, I think that may be more difficult for an employer to establish as a matter of law anyway. That might be form of a question for the jury.
Different ways of saying these are factual issues for the jury. I mean, you could say he has 16 years of experience, of more experience, but if the evidence showed that the employer only gave merit increases and it had nothing to do with experience, then that's not a relevant fact. So, I mean, it seems to me it's always very fact dependent. So I don't know how this case kind of draws a bright line in the way you're suggesting.
I think the federal cases that we have cited all say that the objective evidence alone, such as experience difference, should get you there. This is not, and the plaintiff could have brought an intent-based discrimination claim and got into some of those issues. It's the lower burden for the strict liability case is what we were addressing here.
Comment about Mayorga and their discussion about the burden does not shift back. Is that the same across the circuits, or did the Eighth Circuit take a different view from other circuits?
I believe the Ninth Circuit does have some cases that suggest there is a final burden shifting, and they would address some of those. I know the plaintiff cited the Cooper case out of the Northern District of California, where the court did go on and take a look at further evidence after the employer presented evidence that experience should carry the day. So I'm not exactly sure the extent of the circuit split, but I do know that the Eighth Circuit cases indicate that there is no burden shifting back once the employer comes forward.
Yeah, I understand your point about, your argument is it's sort of unfair for the employer to be put to a comparison of a hiring decision in a salary range that's whatever 15 years before another hiring decision in a salary range. But what if it had only been 1 year? I mean, isn't there a point at which it's a valid comparison? What if Ms. Selden the year after had been hired at the bottom of the range, and the year before Mr. Jaden had been hired at the top of the range?
Yes, I agree. I think that the timing does matter, and the period between the comparators. Obviously, we don't have that here. We've got a 16-year period, but if it was 1 or 2 years, as the court suggests, I think it would be more problematic for the employer to establish the factor other than sex.
How many years are too many is too long to compare?
The court has to come up with a bright line rule today based on the facts in this case. I do know that the facts in this case with the 16-year gap should be enough to, on the facts of this case, establish it. We looked, certainly, for any case under the Federal Equal Pay Act. We couldn't find a single one where the court permitted a 16-year gap in the comparison. We also looked through every case, and we couldn't find a single one in the nation where the court permitted a hiring range percentage to be compared. This is a novel case. This would be the first case in the nation if the court were to permit this. And
The 16-year gap, is it the number of years that's the problem, or is it the change in circumstances between that time frame that makes it a different situation?
probably both. I mean, I think there's an implied change of circumstances over 16 years that's going to happen. There's also evidence in the case record on that, on the different market conditions, as Jaden was hired close to the change in the millennium. So there was the Y2K rush and the urgency of trying to find programmers. So that's one reason that his supervisor recommended a higher percentage in his range. 16 years later, there are different circumstances. Evidence in the record shows that Selden was not facing, there were more programmers available. There was no urgency around the country with regard to programming issues.
A little bit about damages and footnote 7 of Dindinger. And I mean, I guess my question is this: the footnote says what it says. So what's your response?
Well, I hope we can agree that the footnote in Dindinger is dicta, because at the time the court was addressing whether 216.6 would permit wage discrimination claims. I hope the court would be willing to look at this afresh, despite that footnote. But it is a difficult kind of analysis. But the way we look at it is, at the time the Iowa legislature passed the Equal Pay Act, 216.1513 already provided for all claims under the Chapter 16, the 300-day exhaustion requirement. And then when the legislature did adopt it, they put in the language, for the period of time for which the complainant has been discriminated against. And so the question is, how are we going to read these two together? We think it'd be an absurd result that the legislature intended that the 300-day requirement be written out, because this is a claim under the chapter. And that would be a bad result.
Yeah, but, I'm going to defend my footnote, if that's okay. First of all, it's a certified question, so one could argue the whole opinion is dicta. We're asked to provide dicta. It's not our case. But secondly, when you're talking about equal pay, let's say there's been a discrepancy in pay, which is alleged here. There's a number of legal issues that have been raised that took place over years and years and years and years. And the employee learns of the discrepancy in pay and files suit. Unlike in many civil rights cases where you're talking about a discrete action that's been taken in the recent past, here you're talking about something that happened over a long period of time, where the main remedy is going to be retrospective rather than prospective. Isn't it arguably, kind of a little unfair to limit the employee to 300 days?
I don't think so, Your Honor. Particularly if we look at the word discriminate, when the legislature put in there for the period of discrimination, I think the only way to really look at that is that it means the period that the plaintiff has preserved the discrimination claim. After all, it's not discrimination until the plaintiff proves it's discrimination. There's no period of discrimination until discrimination is proved within the meaning of Chapter 216. I think that's one way we can actually read both parts of the Equal Pay Act under Iowa law.
The limitations in the federal Equal Pay Act.
2 years. That was the Lidley Ledbetter exception that came in, and the Congress specifically put a 2-year limitation in there. And at the time,
To the extent that the Iowa legislation tracks the federal, and I think it does, with the exception of this 2-year limitation on damages, why can't we infer from that the damages period is longer than the federal?
I mean, that's a fair question, Your Honor. The legislature did not do what the Congress did and put a specific 2-year statute of limitation in there.
Was it 2015 when that proposal was submitted and then the Senate did not pass that?
Another fair question. I think it's difficult to discern legislative intent even with a passed bill that becomes law. With a bill that's just proposed and withdrawn, it's even harder to discern what the intent of the legislature was. We don't.
Language that was already in there that they were trying to amend.
It's hard to infer that. I'm not sure why that bill was withdrawn. Maybe it was withdrawn because they did believe that 216.1513, the 300-day period of exhaustion, which this court has also construed to be a statute of limitations, maybe they believe that was going to carry the day. I mean, it's just hard to predict or to speculate what the legislature was thinking with that bill that was never passed.
Was the jury verdict for emotional distress excessive?
Honor, I have argued before this court before about whether Jasper versus Nizam is still the law here, and we would really like to have the court reaffirm that is the case. We also believe that the retaliation verdict should be reversed based on our briefing, but with regard to excessiveness, here this $400,000 plus award for the retaliation claim with no medical treatment and very, very little evidence in the record of any harm that actually happened to the plaintiff should be able to stand. And we also believe that in response to our briefing, that the plaintiff has kind of not just grossly exaggerated the record, but come up with some evidence that's not in the record to support emotional stress, such as the father of Selden could not recognize her. That wasn't anywhere in the record, or that Selden was up at night at 3 a.m. Maybe that's from a different case, but it's not in this one. It's not in this record. So with the scarce amount of evidence here, we believe that amount's excessive. We believe Jasper versus Nysum is still good law, and that plaintiffs that don't have medical treatments or evidence of more severe emotional distress should be in the lower range of damages. I see that my time is up, so I shall yield at this time.
Thank you. Mr. Albrecht?
May it please the court, counsel. Taking a few of the issues that came up in the order in which they did, 216.6a sets out that it's the employer's burden to prove an affirmative defense, not offer a factor other than sex. They have to prove that it was the reason for the wage differential there. And in this case, they simply did not do so. Justice McDonald, I believe you talked.
I mean, the evidence to counter what they put on about the market conditions leading up to Y2K. And in addition, didn't Jaden testify, I asked for the same amount I'd been getting at my prior employer, and that's what I needed to receive. Isn't that what he said? And so that's what they gave him. Doesn't that sound like factors other than sex?
Prior salary cannot be used. And if we look at the defendant's hiring policy, it's found in Exhibit F4.
Well, it can't be used. I mean, as I read the cases, an employer can't just look at somebody's salary and say, that's what I'm going to pay that person, maybe plus a little bit to get them to move. And that's probably not a sex-neutral policy. But if a specific employee says, if you want me, this is what I need to make, that sounds like a market-based determination, right?
The problem there, Judge, is the defendant's policies don't allow for that. So there are hiring rate policies. Again, it's in that Exhibit F4. And
Selden, no? Didn't they offer her 68 and she countered with 72 and then they settled on 70? Isn't that kind of the same thing?
It's not the same thing, though, in the sense that the market forces theory says that you can't justify paying women less because they'll accept less. And
That's different than saying, I think you have to couple the, Mr. Jaden saying, I need 46, whatever it was, to move, with the Y2K and it was a new position. There are a lot of things that were going on that go to market condition that don't have anything to do with, we just women will accept less, so that's a market condition. Those are two different things, aren't they?
these other points, this Y2K thing. First, I want to make it clear. The Y2K excuse, the first time it came up was trial. So when DMAC defended against Sandy's civil rights complaint, they never mentioned Y2K. They never mentioned economic conditions. When HR responded to Sandy's pay complaint in January 2019, they never mentioned market conditions. Mr. Jaden testified nobody brought up Y2K, nobody brought up urgent hiring needs. Linda Fitterlick, who's the supervisor who retired in 2019, she was on the hiring committee for Mr. Jaden. Y2K never came up, she testified.
The theory they presented was not that Y2K was a problem for DMAC because they had this new enterprise software, but that it affected the hiring market. And you didn't present anything that countered that, did you?
Their economist, Your Honor, and a few other points on that. The urgent need theory, again, under DMAC's policy, if you wanted to give an advanced hiring rate, you needed to justify it in writing. And even with an advanced hiring rate, it's not supposed to go above 50% of the salary range. They violated that in going above that to 54%. In addition, Mr. Gurian, the economist, did not testify with any certainty about his projections. He was asked, how sure are you about this? His testimony was, I can't put a percentage on it. I think it's up for the jury to listen to me and decide if they believe me. This is a fact-driven argument. As DMAC's post-trial motions indicated, they said this could have impacted. Could have is not judgment as a matter of law.
That you presented to the jury. So let's assume a different fact pattern, okay? Let's assume you have an employee 10 years ago who's hired at a coffee shop, a man. He's paid $8.25 an hour, so $1 above minimum wage. Now you have the same coffee shop hire a female employee, let's say $15 an hour, which is more than double the minimum wage. Does the male employee have a cause of action under your theory?
Does the male employee? I think that would be, the problem is with all these cases is they're fact-driven. I think if the employer is going to justify the wage differential, what they're paying the female in the future based on factors other than sex, then they will prove their affirmative defense.
Be, I mean, this person was only paid $1 an hour above the minimum wage. The new employee is paid more than almost $8 an hour above the minimum wage. What? Under your theory, that's actionable, right?
Because our theory looks at how the employer valued the position, which is governed within the salary ranges, which, contrary to what the defendant says, is not a novel theory. Ledbetter looked at this.
In my hypothetical, the employer says, this employee only deserves $1 more than this particular fixed point, which is the minimum wage. The second employee deserves $8 an hour more than the minimum wage. I mean, it's the same thing that you're arguing.
I would say, first and foremost, that if a jury thought that it wasn't proven, then they would find against it. The evidence used in this case and in your hypothetical is up for the jury to decide whether or not they accept it. And if they believe that it's too attenuated, they will reject the plaintiff's argument. Here,
I guess I find that very problematic, given just basic inflation and economics, that you can take two people hired 15 years apart and you have entirely different salary structures and ranges. And then you just say, well, that's a prima facie case of discrimination and the employer can put on an affirmative defense. I'm not sure how that works on the ground in reality.
this case was actually perfectly teed up for this because they were in the same position, governed by the same policies, which had the same hiring rate policies consistent from 1998 to 2013, and they had the same pay grade. The only way to compare these folks across different timeframes was to look at the applicable pay bands.
About the bands, because I had a question about the math on that, all right? So I'm looking at Appendix 22, which is when Jaden was hired, and it says their salary range in the advertisement, $36,000 to $54,000, and he came in at 46, and I agree with your math. That's 54% of the difference. Then I look at Ms. Selden, and here's the advertisement that she responded to, and it said hiring range 64,000 to 81,000, and she came in at 70, and that, by my calculation, is about 32%. But I keep hearing 15% in the brief, and at trial. Can you clarify that for me?
Yeah, I don't have those papers in front of me. However, we took the specific documents, and it would be in the record as to if we were citing from the advertisement or a different document to get the 15% within the hiring range. It's not something that DMAC's challenging on appeal.
Trying to, figure out, I mean, it does get to, kind of what Justice McDonald is raising. Can you even do these kind of comparisons? It strikes me that what you did do is you took the bottom of the hiring range and then compare that to the top of what anyone was being paid at that time to do the job, even if they had years and years of experience. And that strikes me, that's kind of an apples and oranges comparison, to compare that in 2013 to something else in 1997, 98.
Hiring ranges, not hiring range to salary range, which are two different things. And again, the percentages we came up with are those, we cite them in the record. I don't have the specific document in front of me, Justice McDonald, Justice Mansfield. But as you pointed out earlier, and actually you sort of talked about this in the Dindinger opinion when talking about how unfair labor practices can apply to people at different time frames. On page 573, you said, a hypothetical, could an employer escape liability by hiring a woman and paying her less based on a discriminatory pay practice adopted 10 years earlier? Surely not. That's what we did here. And from your example earlier of if it was 1 year or 3 years, and I believe opposing counsel said, yeah, that would be pretty tough for the employer. As that time frame expands, it simply becomes a matter of scale. And if the jury felt that that evidence was too attenuated, they would have rejected our argument and found for the defendant.
The damages calculation then, if I understand Exhibit 30, damages were calculated based on the difference between what Ms. Selden was paid and what she would have been paid if she had started at the same percentage place in the salary range. Is that right?
Yes.
How does that comply with the statute, which says damages have to be calculated based on the wage differential paid to another employee compared to the complainant? I mean, the statute's very clear on how you calculate it, and you're comparing her to a hypothetical employee herself.
I don't think it's very clear on how the wage differential needs to be calculated, because as to Justice Mansfield's hypothetical, if it was 1 year or 3 years apart, you would not compare the wages actually being paid at the time the complainant brings the charge, because there are non-discriminatory factors at play, that 1 year of raises or those 3 years of raises. And so what we looked at is the law's purpose, which is to put the plaintiff in the position they would have been in absent discrimination.
I don't know why you say it's unclear. The statute doesn't say that. It says very clearly, quote, damages an amount equal to 2 times the wage differential paid to another employee compared to the complainant. So there's nothing in this chart that has salary information for another employee. It's just a hypothetical salary based on the percentage. And if you're saying your theory doesn't comply with the damages statute, then maybe that's a problem with the theory.
No, I think that when you're looking at what a wage differential constitutes, the way that I think that you're saying it and the way that DMAC actually seems to be arguing is that in 2013, Sandy should have been saying that she should make the exact same amount that Brian Jaden was making in 2013. That would punish DMAC for those 15 years of raises that Mr. Jaden got. And so it can't be the wages actually, I mean, in some cases it could be the wages being actually paid at that time if the two individuals were hired at the same time. However, in this case, we did have a time differential between the people being hired. So the question became, what is the clearest and fairest way to make that comparison? How is the jury to decide, well, what would she have been being paid absent discrimination? Now, we could start with their pay in 2013, but then we would have had to shed away the 15 years of raises that Mr.
That has used the range theory.
You're talking about the Eighth Circuit Ledbetter case, right? Versus Altel. That was a discrimination case, intentional discrimination case. That was not equal pay. And they were trying to calculate back pay for intentional discrimination, not equal pay, as I read that case. Am I wrong about that?
But the difference between those two cases in what you're talking about, Justice Oxley, would then be the difference between the intent, sex discrimination versus wage.
Go to Justice McDonald's question, that the Equal Pay Act has very different damages than an intentional discrimination case.
Same damages in back pay. They have the different recovery period in 2 years versus the period of time for which.
For it, though. Is there not?
What, you mean by the multiplier? I mean, so in EP.
It specifically says the differential.
I don't know that I agree with that. I think when we're looking at the difference in the Ledbetter case, if it's calculating damages, it's simply saying that this is evidence you can use to prove what the back pay would have been. We also cite, I think there's a Marshall case and additional cases. There simply was not, we thought that this was our best route to put on evidence to calculate what that wage differential is, because it can change. If an employer is paying men greater raises than women, more frequent raises than women.
Hypothetical. All right, I was doing spin class at the Y this morning where I get all my good information. And the instructor said that she's switching jobs, and where she's going to work, they're going to give her a bonus when she starts, and then if she's still there at the end of the year, a bonus at the end of the year. So let's say there's a guy working in the same job. Does he get to raise an Equal Pay Act claim against her? You know, not against her, against the employer using her as a comparator?
I think that if they're in the same position, doing similar work in the same establishment, he can bring a claim. That doesn't mean he's going to win. Look, the burden is on the employer to prove its affirmative defense. The Channon case from 2001 says it is rarely the case when an affirmative defense will be proven as a matter of law for J&OV.
A difficult result, especially when you don't have this situation, but you have the situation of when you have a situation like you have here, where it was 15 years earlier that the hiring decision was made, and the person who did the hiring is no longer even with the company.
Fired, may I respond? Justice Mansfield, I would say that would be governed and should have been governed by the defendant's policies. You mentioned Art Ferris at the beginning. He was around. They chose not to call him. They did not depose him. They put on no evidence of that. They could have. Their policies required paperwork in the file to justify advanced hiring rates. That paperwork did not exist. It was up to the jury to determine whether the defendant proved its case as a matter of law, and they said that it did not.
Question. I'm bothered by this notion on the limitations period that a party could wait until retirement, right? You could wait, I think, under your theory, 40 or 45 years to bring a claim like this and then recover for that entire period. And typically, we wouldn't permit that. So why is that allowed here?
I would say because the statutory language specifically states the period of time, which says for these claims, we're setting up a new recovery period. That's that phrase, for a period of time for which the complainant has been discriminated against. Justice Mansfield defended his footnote in Dindinger, but on page 575 of that opinion, there's additional language that says, except for the new provision in 2009, which is the 216-6A claim, there are no other parts of the Iowa Civil Rights Act that allow for damages going back to the date the employer initially discriminated. So you actually made the point at least twice. To your point, Justice McDermott, I would say first and foremost, I don't really think that it's realistic that somebody is going to sit if they feel like they're being paid less and they're not going to say anything intentionally and they're going to sit on their hands in the hopes that later maybe they can prove a lawsuit. However, what this court also said in Dindinger is that it's always fair to hold the employer accountable for these things because they are in the best position to know whether or not they're paying people fairly. And so I think in that case, Your Honor, it would fall upon the employer because they're the ones who know and have the information as to whether or not they're applying their discriminatory or their pay practices fairly.
One more question, I'm sorry. Could you respond, you mentioned Channon and the heightened burden there that we talk about. Channon also was not an Equal Pay Act claim. Can you just respond briefly to the Mayorga case from the Eighth Circuit and their discussion of that there's no pretextual burden shifting back once the defendant proves their defense?
Say, Your Honor, is that I think this court said in a recent case that, yeah, the burden shifting of McDonnell Douglas doesn't necessarily apply at trial. However, if we look at the Dindinger Eighth Circuit opinion, the plaintiff there was able to put on evidence, the exact same kind of evidence we were to put on. And what the Eighth Circuit said was that was relevant and admissible to rebut the affirmative defense proffered by the defendant. And so I think if the statute said something different, like an employer needs to merely offer, I don't know, a legitimate reason or something, maybe it's a different discussion. But the legislation says that they must prove that a factor other than sex caused the differential. And even the other circuits say they still must prove it. And so I would go back to that Dindinger Eighth Circuit opinion, which states that the plaintiff is still able to put on evidence to rebut any of the affirmative defenses.
Ask you to respond to, this is my concern, kind of the conceptual issue I'm having with this. As I understand equal pay claims, you look at the compensation of the employees now, and if they're in the same position, doing similar work, you see if they're being paid the same compensation. And then if they're not, then the employer has a burden of putting on affirmative defense for some particular reason, seniority, merit, market conditions, whatever. But it seems like what you're doing is by creating this like starting range theory is you've kind of turned the affirmative defense itself into the cause of action. You're kind of weaponizing it. So these people aren't being paid the same wage now, which is the relevant comparison. And they say, it seems to me quite logically, well, they're hired years and years apart by different people under different market conditions. And then it seems like your theory is like every step along the way, you have to justify and have equal compensation at year 1, year 2, year 3, year 4, year 5. It seems conceptually that's just wrong. I want you to respond to that. It's not a great question, but that's the issue I'm struggling with.
Question, along with defendant's argument, sort of conflates the liability portion with the damages portion. So the liability portion is merely, are they in the same position, same environment, same job responsibilities? Are they being paid equally or not? And if the jury says, yes, there's a problem there, the man's being paid more than the woman in this case, then the employer can put on its affirmative defenses. I think that's a separate question from them calculating the damages, because when you have cases like 216.6a envisions, because it says that a discriminatory pay practice occurs even when somebody is then subject to a prior practice, what you have there is you might have a mixed bag of discriminatory and non-discriminatory factors that are compensating or that are the reason for that pay difference at the time the person brings the claim. And so our view would have been, is it would be unfair to DMAC to say that Sandy somehow gets the benefit of those additional years of Mr. Jaden, because again, the point of the discrimination case is to put the plaintiff in the position they would have been absent discrimination. Absent discrimination, Sandy wouldn't have been making the same amount of Mr. Jaden in 2013 because he had more raises. And so what we did was we just looked at the hiring ranges, which again, in the Ledbetter opinion, they say, if there was no discrimination, here's what the person would have been paid. And that allowed us to take away the non-discriminatory reasons. We could have compared them in 2013 and then started shedding away the raises, like I mentioned earlier. We would have ended up at the same place. And even their economics person, Dr. Gurian, said you cannot simply compare the 46,000 in 1998 to the 70 because you have to compare them and consider things like inflation. Our resolution to that was to look at them in the way that DMAC looks at them, the specific policies governing hiring rates for the specific A6 pay grade. That was the best way to compare them, to take out the non-discriminatory factors to give DMAC the benefit of those, while still giving the jury an ability to say what position would Sandy have been in absent discrimination.
Could I ask one? Could you briefly respond to, or at length respond to the defendant's point, and also amicus, I believe, about the emotional damages and whether there should be some guardrails in these cases?
So for emotional distress, one thing I think is important is the jury made 4 separate awards here. And while it might be tempting to do what the defendant does and lump them all together, those were 4 awards, and they must be viewed independently. But in general, I think that the guardrails have already been set. Each case is to be determined on its own merit. It is going to be decided by the 8 individuals in the jury box who bring their own collective experience and wisdom to that. In this case, they found that Sandy had suffered emotional distress, both past and future, in the amounts given. The district court heard that, upheld that. That was not an abuse of discretion. I think there are guardrails, and I think that it's worth mentioning, because reading the amicus, it would seem like any time a jury gets a case, they run with it. In the last 5 years, for employment cases that go to trial, there are more defense verdicts than plaintiff's verdicts. It is not as if juries don't understand. I've gone to several CLEs, including when members of this court have presented, and they keep telling us, juries are smart, juries get it. And I agree. And that range of verdicts from 0 to $1 million is something that should be celebrated, not silenced. And so I think that the guardrails, Justice May, are already properly there. There has to be the evidence, and the 8 people in the jury box who bring their humanity to discuss how this person's humanity was harmed. That's something that, unless the awards, independently considered, shock the conscience, that this court should keep there. Of course, barring our cross appeal regarding the emotional distress damages for 216-6A claims. With that, Your Honor, we would just simply ask this court to affirm the district court in denying the JNOV and the motion for new trial or remittitor, but to reverse the district court's interpretation that emotional distress damages do not qualify as damages for a 216-6A plaintiff. Thank you.
May it please the court. Only got 5 minutes, but Justice May, I do want to address a little bit of the emotional distress question, partly because many of the cases that have been cited in these briefs were cases that I personally was involved in. I actually represented the plaintiff in the Kim versus Nash Finch case and the Frazier versus IBP, and then the defendant in Haskenhoff, Hawkins, and Rumsey, all of which this court has looked at in different ways on the emotional distress question. I have talked to the jurors after all those cases to find out. Sometimes these are large verdicts. I'd like to know. The problem that I see, and I think the amicus has put their thumb on this, is the juries themselves don't know what the guardrails are or the limitations are. They don't know the history of the cases or the law. And so they're just thrown into this and they just don't know. The first person in the jury that says $1 million, the rest of them say, sounds good. Without some way to instruct the jury as to what the guardrails are or what it should be, it seems to be they're not guided to what a fair emotional distress award should be. I completely agree that emotional distress should be part of it, but an uninstructed, unguided jury, really they don't know what they're doing, and that's part of the problem here, which is why earlier I talked about Jasper versus Neisman and why I think that should.
In your response to Mr. Albrecht's point that when Mr. Jaden was hired in 1998, that it was a violation of the policy to put him at more than 50% of the range that was in the application for that particular position.
I don't believe that was a violation of the policy at all. At that time, the policy did permit the employer to have the hiring supervisor come up with a written justification for a hire, and that's what the supervisor, Art Ferris, did. He put together a recommendation to deviate from the range, and his supervisor, I believe, looked at that and approved it. It certainly wasn't a violation of the policy at the time, and I do believe that it was part of the market conditions at the time to negotiate with him to get the salary that he wanted. I don't see that it was any kind of a violation of the DMAC policy at the time. Don't have a lot of time, but I do know this court is going to be addressing this statute, and there's a couple other, I think, problematic parts of 216.6A. One is willfulness. The legislature did not do us any favor by not including a definition of what willful is in that statute, and this became a problem at trial with the defense counsel proposing a willfulness standard of evil or corrupt motive, and the plaintiff's proposing instruction more aligned with 668 punitive damages, which is new or in reckless disregard of, and that's the instruction that ended up going to the jury, and that's a bit problematic because then that allowed the plaintiff to argue that DMAC knew there was a difference in pay between the men and the women. That's different than knowing that sex had played a part in the hiring. In particular, when you overlay a strict liability standard on this, that becomes an impossible willfulness standard. The Federal Equal Pay Act does have its own definition of willfulness. It was not adopted by the legislature at the time. So, and the other aspect the court will look at under 216.6A is whether it permits emotional distress. We believe the district court did correctly conclude that when the legislature adopted 216.6A, it knew that actual damages included emotional distress as well as retirement benefits, and chose not to put that in the relief section for 216.6A, which indicates that emotional distress should not be permitted for the strict liability claims. And further, with regard to this case, we believe that DMEC did not get a fair trial because when the evidence came in, there was a lot, we've cited it in our briefs, of emotional distress evidence with regard to the wage discrimination claim that came in. And then, of course, the district court, we believe, did the right thing after the jury entered its verdict in post-trial motions and took away the emotional distress, but we believe the unfair prejudice remained.
Ask you about the retaliation claim. There was no direct evidence of retaliation, but you do have this situation where about 3 months after Ms. Selden makes her complaint about pay equity, the very person that is addressing that complaint then screens her out for this supervisory position. Why isn't that enough to get to the jury?
The proximity, you can't assume it from 3 months. This court has often said that's not the case. But two reasons. One is the qualifications requirement of having the computer science degree is a requirement. We cited the Sims case. It's an Eighth Circuit case that said that because there's a degree that was required for the position and the person didn't have it that was applying it, that court said the only way to raise an inference in the lack of direct evidence is to show that the person that got the position also did not have the required degree, and it didn't happen here. In this case, the person that was hired did have the degree in computer science.
Oh, go ahead.
Did everyone else that made it through that initial cut also have a bachelor's in computer science?
I believe, Your Honor, the 5 people that were all screened out did not have it, which is another indication that we shouldn't raise an inference of retaliation.
Have a bachelor's in something else, just not computer science?
Your Honor, I'm not that familiar with the record to get down to that level of detail. But the other reason, Your Honor, is that there should be some other evidence of causation here, which we think was lacking, and it's because the decision maker, Lacey, screened out all 5 people that didn't have it, and there's just no evidence she did that.
Things go to a jury. I mean, isn't it a factual question? Couldn't the fact that they even put down, you know what, I think we are going to require a bachelor's degree. Let's throw that in there, then she wouldn't qualify. Couldn't that be a factual issue for a jury to decide to at least get it to beyond summary judgment?
Except for in this case, they added the requirement for the bachelor's degree back in 2007. So it was already in place. This wasn't a new requirement that threw in at the time.
When he was hired, he didn't have a bachelor's and it wasn't required. Is that correct?
Linda Fitterlich had been a longtime employee there, and then she was promoted to that position prior to 2007, did not have that degree, but at the time, DMAC's policies permitted her to stay in the supervisory role, even though they had changed going forward in 2007, that requirement. So by the time she retired in 2019, that was a permanent part of the requirements.
About originally, I cannot remember his name, they made an exception based on the market. I don't doubt that Y2K and all that stuff was scaring and freaking out some companies, and they might have decided to hire people and pay a premium to try and help them in that situation. Could a similar exception have been made by them? Is that also a factual question? If they made an exception many years ago for him to pay him well above and beyond, could they have made an exception regarding the bachelor's degree? I'm just trying to think of a way that perhaps the DMAC did make it a little bit harder on her because of her complaints.
When Jane was originally hired, it wasn't in the supervisory position and didn't have that degree requirement. So I'm not sure we can compare that to the requirements for the supervisor position that much later. And there's just, because of the way this happened, there's just no evidence that discretion was used to substitute the degree for experience. We know that the 5 people that didn't have the degree, were excluded. And the 4 that made it did have that degree. So with that kind of a record, there's nothing that establishes that DMAC used any sort of discretion or deviated from that requirement at the time. And with that, I know I'm past my time, but Des Moines Area Community College respectfully requests that the court reverse the jury verdict and enter judgment in favor of Des Moines Area Community College.
versus Des Moines Area Community College is hereby submitted. And we will just pause a few minutes here while the attorneys trade places for our next case.